So psychosocial hazards.
Thanks, Phil. And I think, it's really important we're talking about this topic, all of these topics today, because the New South Wales government are throwing buckets of money at this stuff. They've implemented codes of practice, legislation, and we've only just heard that they are appointing 4 specific psychosocial inspectors in New South Wales.
Sorry. So what do we actually mean when we talk about psychosocial hazards? They are defined in legislation as hazards that arise from or relate to the design or management of work, a work environment, plant in the workplace, workplace interactions or behaviour, and may cause psychological harm. What might they look like in practice? We've got some common ones up here on the slide, and you can see that they range from the more serious end, so things like occupational violence and aggression, to some things that might seem more lower level or innocuous, like overload, poor support in a role, and that kind of thing. It's important to just say about these at this point that when you're thinking about whether they're rising to the level of psychological harm, not to kind of put your own view onto when that would reach that level. It's not an objective test. What matters is the risk to the individual and how they are reacting in the circumstances. So it's important to keep that in mind.
Sorry, that was our laptop.
Oh, thank you. Yeah. Okay.
Don't you just hate it when it's just a button?
Yeah.
Okay. Yeah, I mean, some of the more low-level ones, like overload and underload, it's really important to not look at this list and think, well, we know what a reasonable load is. What's really important when you're looking at all of these things is that the way that we have to approach this is in a workers' comp context. And what I mean by that is that you take your employees as they come. The day they walk in the door, or 6 weeks later when they develop a condition, whatever it is, you take your employees at that level. And what I'm speaking legally, what they call that is the eggshell skull theory, or the eggshell psyche, which means that if someone has a lower threshold, an individual has a lower threshold, you have an obligation to take that into account. So when you're talking about overload and when you're trying to manage, let's say, a bank of, or one of your divisional leaders is sales manager is trying to manage their sales team, and they've got 5 salespeople who all have the same targets, and you say, well, you've all got the same targets. It may be that one of them, or 2 of them, hopefully not 2, does not have the ability from a psychological perspective to manage that same workload. There are ways to deal with that, and we might get to that, but we might get to that in questions today. But it's not easy. It's like performance management, but it's a different approach. But you've got to understand that this is not about resilience and about everyone having to meet a certain level. This is about actually leaning into and understanding where people's weaknesses are, where their thresholds are, and they are different thresholds.
All right. So what happens when employers get this wrong? We wanted to include this case study quite early on in the presentation because it's an important example to share, to just underscore some of the seriousness of what we're going to talk about today. So this case was the first of its kind against a Commonwealth government employer. The Department of Defence was convicted under the Work Health and Safety Act and pleaded guilty, I believe, to failing to take reasonably practical measures to eliminate psychosocial risks in the workplace. And they were fined $188,000. So this case concerned a 34-year-old Air Force technician who died by suicide while he was on duty at the RAF base in Williamtown. Now, he was in the process of being performance managed, and he'd been subject to 4 performance work plans over a period of 6 months. And during the process, the worker was displaying signs of distress and ill health. But despite this, the supervisors and managers who were running the process failed to stop the process, place him on leave, or take any measures like that. And in the course of the court proceeding, the court found that these risks were actually foreseeable because defence had policies in place where they should have known that this was a risky thing, and the process should have been suspended. So the key takeaway from this case is that psychosocial risks can lead to liability for businesses. Here, defence was fined, and I believe there's also an adverse publicity order as well. And the other takeaway is that policies alone are not going to be sufficient to manage these risks. What matters is oversight, implementation, and training, and knowing when you need to step in.
I think what I found really impactful about this case is that effectively you've got a federal government department, and one that's known for its discipline, the Defence Forces, and governments are known for process. When you go to a government department or you work in a government department, you expect that those processes are well thought out, well planned, and well implemented. And that hasn't happened here. And you've got a government department in that environment effectively being found responsible for this person's suicide. So I just thought that was really impactful. The other thing I thought was it's a really good lesson that even though you have these policies and procedures, we cannot sit back and go, oh, great, we've got the policies now and procedures, we can let them run. There needs to be a live and real review of what's happening along the way from a psychosocial perspective. That means you can't just rely on your processes and expect that they will defend you. You can't expect that your policies will just defend the organisation. You have to think in the circumstances of what's happening at that point in time with that particular individual, and sometimes you'll have to deviate, and that means policies, procedures, and the like will need to contemplate that as well. So if you've got rigid policies and procedures, you need to be able to contemplate. Well, you need to be able to deviate partway through a process and build a different process sometimes.
All right. We've got here another example of the risks that can arise from businesses' management of psychosocial risks. You may have seen this High Court decision from 2024. It was pretty significant because it changed the law. But we wanted to include it from a psychosocial risk point of view. And I'll just give you a bit of a recap of the facts. So this case concerned Mr. Elisha, who was a long-term employee of Vision Australia. He was involved in an incident on a work trip, which ultimately led to his employer commencing a misconduct process against him in accordance with its disciplinary procedure. Mr. Elisha denied any misconduct, but ultimately his employment was terminated. He later was diagnosed with a major depressive disorder, and he commenced proceedings against his employer in the Supreme Court in Victoria for damages for his psychiatric injury. This decision, in the first instance, it was decided in his favour, and it went all the way up to the High Court on appeal. And the High Court again found in Mr. Elisha's favour and awarded him $1.5 million in damages. The key about this case was that the procedure that governed the misconduct process was incorporated into Mr. Elisha's contract. So it was a breach of contract claim that led to the finding of liability for his psychological injury. So from a psychosocial risk perspective, it's another example of why it's important to make sure you follow the policies and ensure that there's policies that apply to conduct, but also important to make sure that the policies don't form part of employment contracts, because now the High Court's changed the law in this area, and there is a risk of liability for psychiatric injury if the policy is incorporated because of a breach of contract.
And I think just so it doesn't look like Caroline's contradicting what I said before about your policies being able to deviate from the policies, what I was saying was the policies need to let you do that. If you have rigid policies and they form part of your contract, you can find yourself in a very difficult situation trying to manage a particular scenario if you don't have the ability to flex within the policy. There has to be that ability to deviate. It can't be rigid. In this case, the other thing that's really interesting, as Caroline has said, from an employer's perspective, the way a lot of employers think is, oh, look, if someone suffers an injury at work, we're okay. We've got it. We've got workers' comp. Well, what this case changed was the law in relation to, as Caroline said, seeking damages for psychological injury. The law up until this point said you cannot seek damages for loss, for psychological injury, compensation, for breach of contract. This case went all the way to the High Court, and they've changed the law on that. The High Court have said now, no, you can claim damages. So you'll see a lot more employee claims that include a claim for breach of contract for psychological injury. And what that money often comes out of your pocket as a business. It doesn't come out of the workers' comp bucket. You can't rely on your workers' comp insurer for it. They might, if there's a workers' comp claim alongside of this, you might help them settle a claim, and you might even have to contribute to it. So it's an area of liability that you may not have insurance for, and you've got to be careful about. So that having the right policies in place with the right ability to deviate during the process, if it doesn't suit that particular individual or that particular scenario, because there are psychosocial risks, is really important.
All right. Now we're going to get to the key changes that we really wanted to talk about today in this section. The first one, the Safe Work New South Wales Code of Practice on Psychosocial Hazards in the Workplace. And the second, a new regulation that governs psychosocial risks in New South Wales.
Yeah, look, the Code of Practice was the New South Wales was the first one to have this Code of Practice. All the other states and territories have this now. They followed suit. Safe Work Australia adopted one and implemented one, and therefore the other harmonised states jumped on board and territories. The reason the Code of Practice, the reason the regulation is important is because it has now placed a statutory obligation on the Code of Practice. Now, Code of Practice, in a general sense, in the safety world, is guidance, and you can end up being prosecuted for failing to implement a particular measure that may be contemplated in the Code of Practice, but it doesn't have statutory force. Here, if you happen to breach the Code of Practice, the regulation does mean that some of those provisions, or failing to comply with some of those provisions, will expose you to prosecution, even where there's no incident.
Yep, and that's a picture there of the Code of Practice. I think we can move through here. So the other thing that the regulation changed is that it made clear that the legal framework that applies to the management of physical risks, which we're going to come to in a minute, that now is what employers need to apply when they're managing psychosocial risks as well. So the same hierarchy of controls need to be applied, and again, that point around policies no longer being sufficient. So the focus is on the design of work and the features in the workplace, rather than relying on worker resilience and things like that as well.
Sorry.
Oh, sorry. I was just going to say the other key part about the regulation is that it sets out a list of factors that PCBUs need to have regard to when they're applying the hierarchy of controls to psychosocial risks that they've identified.
So in terms of the health and safety obligations themselves, nothing has really changed. These obligations were already there. But what they realised, the government realised, New South Wales government and other governments are following suit around the country, they realised that businesses didn't get it because they didn't get it either. Their their safe work inspectors, we talk about fair work inspectors so much. Safe work inspectors in New South Wales didn't understand how to go about dealing with psychosocial issues in the workplace. So they slowly built up over a number of years, and now they're really hitting their straps with things like the Code of Practice, this change in legislation, and the appointment of specific psychosocial inspectors that I talked about a few minutes ago. But the requirements were always there. So if you were non-compliant before, if you're non-compliant now, you were non-compliant before anyway. These are not new laws. What they are is a refocusing of the existing laws to actually specify, hey, no, you've got to look at this risk, and it's a specific area. And there are specific obligations, as Caroline's just said, that we'll come to.
We've already sort of covered this slide, so we probably don't need to spend a lot of time on it. Are you happy to keep going past? But
oh no, I think you can just mention a few things.
Yeah. The key takeaway is that the regulation now means that the Code of Practice on Psychosocial Risks is operating in the context of this mandatory legal framework. So it's something slightly more than the other codes of practice and than what was in New South Wales before.
So basically an inspector will come in and check that you've complied with the specific requirements of the code. And if you haven't, then they could prosecute. They'll probably issue an improvement notice, or you'd hope they would. Issue an improvement notice, you improve it within the time that they require, but there is an exposure to prosecution.
So this slide just looks at psychosocial hazards as WHS hazards, and it's something that has been around for quite a long time. The concept that in the context of health, for the purposes of work health and safety, it includes psychological health as well as physical health. And we've just explained what psychosocial hazards are in the workplace, the types of things that they arise from.
I think one of the, sorry, I paused there instead of responding to your shunt to me. To use an example, if you have a workplace that has people who have declared, or you've identified, and you've conducted some investigations discreetly to find out if it's the case, but they've identified that they've got ADHD and they find certain things hard to deal with, then you need to factor that into your psychosocial assessment, risk assessment, so that you can manage any hazards or risks that occur in the workplace. And a lot of workplaces are going through that. I know our firms, we're doing that at the moment ourselves. That's why I used it as an example.
Okay, so who can potentially be prosecuted in this space for failures with psychosocial risk management? So at the top of the list, we've got PCBUs, or persons conducting a business or undertaking. So they are a company, the employer. They can also be an individual if there's a sole trader, or a partnership. And their responsibility is to eliminate psychosocial hazards as far as reasonably practicable, or if that's not reasonably practicable, reduce the risks. Those duties can't be transferred or contracted out of. We've also got officers as potentially liable in this space. Officers have a responsibility to undertake due diligence under the Work Health and Safety Act, and that is around ensuring the PCBU is complying with its WHS obligations and identifying and managing psychosocial risks and hazards. Passive reliance on reports and the like is not going to be sufficient for officers to discharge their duties. And the type of roles we're talking about when we're talking about officers, we've got the CEO, CFO, and shadow directors up there on the slide, but senior people in the business might be in the frame as well. Then we also have workers on the list. So workers also have duties under the Work Health and Safety legislation to take reasonable care for their own health and safety, and also that of others in the workplace too.
And look, over the years that we've had this arrangement already in place where officers have this duty of due diligence under the Work Health and Safety legislation that's been in place since 2011 in New South Wales and some of the other jurisdictions. And with workers having to take reasonable care likewise since 2011. Now, what I think is because they've conducted this expansion of this focus on psychosocial risk management and hazard management, I think that we are going to see potentially more prosecutions in relation to officers and workers. And the reason I say that is because this has really brought things like bullying into focus. And bullying, if it's deliberate and it's a concerted effort, and we've all seen that happen in various workplaces before, it's something that's easier to identify than someone not taking reasonable care, for example, in a manual sense. I think we might see some officers prosecuted and potentially some workers even prosecuted with a lot more frequency than we've seen in the past, which is not very often. And I think from the officer perspective, the focus is going to be around, from a due diligence perspective, show us your records. What are you doing around psychosocial health? And they'll say, oh, I've got, because, for years we've had boards getting the reports on health and safety, and they've got lost time injury, and they've got a few other things, and we're addressing these risks. My view would be that all of your boards should now have a subsection with their health and safety section that separately addresses psychosocial health. So say, what are we doing in this? Particularly if you're now embarking upon a very specific campaign internally, or as an organisation, a review to make sure that you are actually meeting these obligations. Having a running, tally or running sheet for the board that sits under that work health and safety aspect would really be a good start. It won't get them off, but at least the safe work inspector will look at it and say, oh, good, you've got a whole section here on psychosocial health. You obviously think this is a very significant issue, and you've even got a specific project that's underway. My view would be that you'd have that separate section. It's a bit like board reports from a work health and safety and an employment perspective. These days, you would have your workplace compliance, your work health and safety, and your psychosocial health.
So what control measures actually are needed to reduce these types of risks? On this slide, we were talking before about how the new regulation in New South Wales has made the hierarchy of controls applicable in the psychosocial context as well. And on this slide, we've got just an image of what that is. Hopefully it's not too tiny to see. And that's now mandatory because of the WHS regulation. So what's required is that the higher order control measures, so the ones up the top in green there, need to be applied first to psychosocial risks. So that's considering elimination and removing the hazard completely. So if that's not reasonably practicable, then you start to look at lower level measures. So things like engineering the design around the hazard, substituting the hazard, can you change the workflow or something like that, or isolating the hazard. So can you kind of separate the person or whatever the risk is from what's happening? If that's not reasonably practicable, then you're looking down at administration. So that's things like policies and procedures, EAP, staff training, that kind of thing. And the very last kind of lowest order control is personal protective equipment. So that might be things like, Joe gave the example of noise cancelling headphones the other day when we were talking about
what I use.
What some examples of this
My
might
PPE.
be. Yeah. So it's going to be really important to show that you've considered the higher order controls and try and apply them first. And we just also wanted to note that when considering what's reasonably practicable, that's the same balancing exercise as when you're looking at managing physical risks as well. So cost alone of a control measure is probably not going to be sufficient, that something's not reasonably practicable.
I think that's right.
Do you want anything on that one?
No, you took my headphone example. So.
Sorry. It's a good example. So you might be thinking about what does this actually look like in practice? How do you go? We've talked about what's needed, but what do you need to do? So we're going to go through some phases of that now. So that's good news. The first phase is identifying hazards. The first point there is plan the process. That is really important because any time and outlay you spend planning it, because it's not going to be a quick process to identify all the hazards that might be present in the workplace, but the time outlay that you spend planning it will be really helpful once we get to the end of the process because it involves a constant review. So we've got on the slide here some ways that you might be able to identify hazards, and they are things like looking at information you already have. So what complaints have been made, any incidents or claims that have been made, and then reviewing some HR data that might be available. So things like absenteeism, turnover, exit interviews, that kind of thing. Consultation, sort of proactive consultation with workers and health and safety representatives can be another way to identify some hazards. But the key is that you really need to look at the work practices in all conditions. So that's why this planning process can be really helpful, to just make sure that you've got enough time to do all the observation that you need to get a picture of potential hazards.
I wanted to say two things about this. One is never forget consultation. I think consultation is actually a great thing. 20 years ago, I would have told you, if you don't have to, don't do it. Don't ask, you don't want to know. But now we've got to know everything. I've also found consultation's a really good way to get on record issues and things before a person, for example, leaves a business. So, for example, if you're going through a termination process with a probationary employee and you want to move them on, and some businesses still take the old view that, well, it's a probationary employee, we can get rid of them any time on a week's notice. So you bring them in without telling them what the meeting's about, and you say, sorry, you haven't qualified during probation, you're leaving. That is a terrible process. You are immediately at risk of a guaranteed workers' comp claim being accepted because you haven't followed any process, you haven't given any regard to the employee having a safe process. You've ambushed them for the meeting. You haven't performance managed them, so they didn't know that they weren't doing the right thing. Guaranteed acceptance of workers' comp claim if it goes through, 100%. The other thing I wanted to say was that what this does mean, and we probably should have this on the slide, but it does mean that businesses who previously haven't asked people about their health on entry into a workplace, every business now needs to be asking health questions, because this is about psychosocial health. We all have psychosocial health obligations as employers and businesses. You have to ask the questions now. Now, some businesses already have quite comprehensive, in fact, have pre-employment medical processes. I'm not suggesting you have to do that as a standard process, but I am suggesting that all businesses have to be asking employees a range of questions, and we won't go through them today, but we will circulate an example of a pre-employment questionnaire. But you have to be asking these questions before people start, because most people don't want to talk about these things, and that's fine. It is their personal health information, but you now have a statutory reason to be asking those questions, certainly in New South Wales and around the country. I would say statutory as well, because you've got a general obligation in those other states and territories, and they have codes of practice focused on psychosocial health. So you must be asking these questions as these people are applying for jobs with your businesses and your organisations.
So once you've done phase one and identified the hazards, the next step is to assess the risks arising from them and prioritise the controls and hazards that you're going to address. So you need to look at the severity of the risk, the likelihood of it arising, the duration and the frequency of the risks arising from the hazards that you identify. As Joe mentioned before, you also need to identify any vulnerable groups in the workplace. So are there any groups of workers who might have a different experience of the risk or experience a particular thing more severely than others? The example that we used before was neurodivergent people. If that's the case, you might need to think about, do you need to do anything differently for that group to make sure that the risk is minimised for them? The other thing that is needed at this stage is to assess any hazards that might interact and have a cumulative impact as well, and what that means for the controls that you might use to address them.
Caroline mentioned neurodivergent, and we know that about 20% of people they believe are neurodivergent anywhere, so that has to be a standard item on your list. So every business needs to have that in mind. It's not, do we have a neurodivergent people? You have to assume you do. And in some industries, it's going to be a hell of a lot higher. Like IT, you might find some workplaces have 80% of the people are neurodivergent. Yeah.
It's also important to return to the language of the new regulation at this point, because it lists some mandatory factors that need to be considered in the context of psychosocial risks. So they're around the design of work, organisation of work, the workload of the individual employees, the physical and social work environment, and then that point that I mentioned before around interacting or cumulative hazards. We also need to think about the information, training, instruction and supervision that is provided as well.
And these are really helpful. These are the types of things that are going to be, these are the headings in your report effectively, so that you can demonstrate to a safe work inspector, we've considered this, here's the headings and here's what we did. And you could almost produce a report if you've done it. And one would hope you had, because you want to document everything you do in this space. You produce that report, safe work inspector is going to be very happy. They see the words neurodivergent, the words psychosocial everywhere. They see a report, they see a specific board reference there. They're already thinking these guys are ahead of the curve. They're doing a lot more than most businesses.
Then we come to deciding what controls are going to be implemented to control the risks. So, and what controls are reasonably practicable to implement. And that comes back to that diagram we were looking at before around working through the higher order controls first before getting to the lower order one. So yes, training and supervision are still important, but they're not the main game in this space. We're really trying to eliminate the hazards and control the work systems themselves. And again, reasonable adjustments where required are really important too.
Yeah, I think you'll find things like coming back to neurodivergent. I know we keep using that as an example because that's something in our workplace that we've been looking at. You've got to think about things like open plan working environments and how you're managing that. We talked about noise cancelling hearing. That's a very simplistic sort of approach, but it really is a way to address or examine what you're doing in the workplace. And obviously, making allowances for people who are unable to work in that environment, who may find certain things overwhelming, allowing them to have a space where they can go. There may be circumstances where you're unable to accommodate that. But if you're unable to accommodate that, what you need to do is keep a detailed record of how you assessed that we just couldn't accommodate this particular scenario or situation.
Yep. We've got some examples here of what good controls can look like in this space. So the clear message out of this list, I think, is that controls need to change the work, not just support the worker. So some work-focused controls that might be appropriate are things like redesigning the roles, adjusting staffing models, making sure there's escalation pathways in place, and limiting people's exposure to traumatic events as well. And as Joe said before, documentation is really important. If it's not documented, it didn't happen. So it's important to make sure that you show you considered the different levels of hierarchy as you're working through, so that you can produce that down the track if you need to.
Yeah, and in fact, there are some potential penalties for not documenting a lot of this stuff as well. And that's, so if it wasn't documented, it didn't happen. I know from an evidentiary perspective, lawyers might be thinking, well, actually, if there's some evidence there, like it did happen, didn't it? But the reason we like to live by that mantra of if it wasn't documented, it didn't happen is one, there are penalties for not documenting it. And two, if you don't document it and you've got an employee who's making a claim and you end up in a court or a tribunal, well, you might find the employee gets believed over the other individual, the manager, the supervisor, whoever's giving the verbal evidence. So we don't like relying on verbal evidence unless it's the only thing we've got.
the fourth phase of managing psychosocial risks is reviewing and monitoring the controls. So once you've identified the hazards, implemented controls, it's really important that you've got this constant review process of identifying potential new hazards and controlling them, and also checking whether the controls you have implemented remain effective. In particular, it's really important to reassess this after incidents happen, people make complaints, or there are some key changes. So something that might start happening is an increase in turnover or something like that. In that context, exit interviews can be a helpful way to just reassess that things remain effective.
Yeah, this is that live review that I was talking about. Like when you are doing things, you need to be reviewing everything. So if you had an investigation policy, that policy, in my view, should have a provision that says, when you provide your report at the end, were there any aspects of the policy, the procedure, anything we do that require further attention, remediation, review, updating, whatever. So that way you've got an investigator who's investigating, for example, a bullying complaint and doing a live review of the bullying policy while they're doing it. Now, they don't have to do a deep dive and update. All they're doing is saying, I noticed there was some provisions that were out of date. I noticed the policy doesn't accommodate this scenario. So that way they are giving that review. Now, that is a double-edged sword. That is a double-edged sword in the sense that if you get an overzealous investigator who writes a report that absolutely pans the terrible policy you've got, it might completely undermine the ability to deal with the scenario that has occurred in accordance with the policy. But there are ways around that. It just does create a little bit more of a mess than existed prior, but it can always be managed so long as you take the time to manage it and the effort.
This is a point we've been making all the way along around documenting the steps that you take when you're identifying hazards and controlling the risks. As Joe said, it's important in New South Wales and things because of the penalties that might flow. And we've mentioned already that New South Wales is really leading the way in this space nationally. So if you followed the New South Wales approach in other states, that will probably stand you in good stead there as well.
Just on this point of documenting evidence, keeping evidence and the like, we're going to talk about AI, and it does dovetail into this stuff a bit. And for example, when we talk about the rise of AI and the fact that we can now record our meetings, we can record every meeting we're having over Teams with clients and friends, but legally we need consent. And usually there is a message that pops up. But the question is that always going to be safe from a health and safety perspective? Is it always going to be safe? Legally, it's not always going to be safe, and health and safety wise, it's not always going to be safe. So you need to think about whether or not there's more you should be doing in relation to the recording of meetings. Having the little pop-up that Teams or Google or one of the other platforms provides you with to cover your legal obligations from a consent perspective is good, but it is not on its own psychologically safe. And I'll give you an example. If you're an employee, let's say we had a particular scenario we've heard about. We've got 3 employees, a salesperson and 2 managers on the phone, and you get on Teams, and the employee drops off, and then those 2 managers keep talking about it, and then all 3 people get the transcript, and the transcript includes a conversation the managers had about that employee. The employee gets the transcript as well. You need to think about that from a risk management perspective before it happens. In the scenario I'm talking about, they obviously hadn't. So that is an unsafe, psychologically unsafe practice for them to allow that to occur. You need to be thinking about that stuff. That's a guaranteed workers' comp claim, guaranteed psychological injury claim. It is hugely problematic.
We've got here a bit of a checklist that tie in, and we've got some more kind of concluding slides that tie all the points we've spoken about today together a little bit more. But having the board level visibility is really important, as well as the accountability and governance process around hazard identification and the controls that you are putting in place, and equally consultation that you take for identifying the hazards should also be documented. We've talked a bit about some of the legal risks at a high level. There's obviously the work health and safety enforcement and prosecution risk, but there's also increased workers' comp exposure, other civil and employment law risks, for example, around bullying claims and the positive duty to eliminate sexual harassment and the like. And there's also potential personal liability for officers and board members as well. On this slide, we've just got some of the key takeaways from today. So I think the main one is around design-led psychosocial safety. So policies alone, yes, they're helpful, but you need more now. Psychosocial risks are more than just an issue for HR. They're a core risk for the business. Rerunning any risk assessments that might have already been done to make sure they comply with the new New South Wales regulations is probably a good idea, as well as identifying where existing controls in place are relying on those lower level control measures in the hierarchy. And as we've said, effective compliance with these rules around psychosocial risks will help deliver benefits across lots of different areas of legal risk. So workers' comp liability, the things we just spoke about, really.
Yeah, definitely. And I think you can drive this through because you need the support and the buy-in from owners and board members and senior management. And I talked earlier about there being a specific part in a report that goes to the board. Senior managers need to buy into that process if it's going to be of any value and meaningful. And that can drive these things, and it can drive that constant review because they want to see an update when they have their monthly meeting. And that means really this is no longer your work health and safety reviews when it comes to policies and procedures. And that's pretty much all of your employment policies these days. They're nearly all health and safety policies now. There used to be a world where you'd have your health and safety policy, your discrimination policy over here that had everything in it, including sexual harassment, and then you had your code of conduct. And you had those 3 documents, and most of it was employment. Nobody got consulted about it. If you were a reasonable employer, you consulted about your safe work policy, your work health and safety policy. You didn't really consult about the others because they were directions. You just imposed those on your employees. We've changed the thinking around this over the years. Well, we've changed our thinking with the legislation and the issues that have arisen in our workforces, particularly since COVID, because psychological injuries and psychological frailties have come to the fore as a result of COVID, in my view. We've seen a marked increase, and it's not just us, it's the statistics through the workers' comp regulators showing that claims have just gone through the roof, absolutely through the roof. And that is because, partly because COVID has created that environment for us. But if you have that monthly review for your board, they see the usefulness in the organisation doing it and everyone else buying into it from a workplace perspective. So it's a good thing. And people being consulted about things, even if you don't do what they want you to do, they feel some ownership, or at least they feel like they've been part of a policy, even though it doesn't say anything that they wanted it to say. They still feel, look, at least I was asked about this. And I have to say, from an employee perspective, when you are consulting with employees, they can provide a lot of value in a policy or a procedure. They come back with a lot of good feedback. I've seen some really good consultation processes where employees have come back and they're actually pretty good at picking up typos too.
It's always helpful. Back to you.
Okay, so talking about, I can't see anything on the screen because I don't have my glasses on. Put this up first. So there's a couple of resources available on HR Command, and one that we haven't mentioned enough, I would say, is probably the psychosocial hazard assessment. So this assessment is actually really, really detailed. So if you go through the assessment, we will send, yes, I did forget to add a QR code to probably the most important pages that you can download stuff and use it. But I will be sending another email. I know, I'm sorry. Another email after this session with all the resources and the slides. But the assessment, for example, it's about almost 40 questions, and they're really detailed. So it'll take you down a path and show you how your business is actually doing, and comparable to other businesses too in your industry too. So highly recommend this tool. It is free. I'm going to send it to anyone. You can use it. If you are using HR Command, you can use psychosocial hazards policy, and any policy that Joe and Caroline have mentioned today. They're also available on HR Command. And something that no one's seen before, because it is absolutely very new. Rambo, as you can see up there, Stallone is actually a customer. I'm just kidding, they're not a client. But this is an example client that we're using, and it's part of our new WHS register on HR Command too. So that's where employees, internal staff, contractors can actually scan a QR code and go through this particular process, find the sort of WHS issue. This one's on a psychosocial hazard that's available, and choosing how severe. And there's obviously more options at the bottom about where was it, what was it about, who was involved, etc., and submits. And this goes to different people in the business too. So there's a workflow that controls all this. But we'll send you some more information about that as we move on.
Questions?
Oh, questions. Let me just
Mine.
check.
It's unlike you to have a question.
Yeah, it's usually.
I do have a question about the part where you guys said before you do the employment, make sure that you include the psychological injury questions as part of your onboarding. So I already do have a pre-medical kind of form that every employee fills out for physical injuries, pre-injuries. So does that mean that I have to add the psychological questions into the exact same form, or do they have to be separate? And yeah.
I mean, I think you've got a choice.
Sorry, I'll just repeat the question for our people online. We've just had a question around what type of questions should be included in a pre-employment medical, and whether psychological questions now need to be included as well.
Yeah, and whether or not they should be in the physical injury or the physical health survey. Yeah. That's probably just a choice for you guys, like as a business, well, I know you work with lots of businesses. So in my view, if it's going to be, you do a lot of work in construction, and actually mental health is quite a big issue in construction. And I would probably, if you have it as a separate form, like that probably gives it that individual status. I know it's a bit simplistic, what I'm suggesting, but some of the simple things in life really make an impression. So having a separate form. But look, I was also a fan of like keeping documents together if you can, and so having it all in one form's fine. It just means the form's going to be longer. That's all.
Okay.
Yeah.
And it's a related question. Also regarding that particular form, going back to the other questions, what kind of questions should we add? And what if the employee lies on the form? What happens for the employer, and what if they refuse to fill out that form? They're happy with the physical but not the psychological.
The question was a follow-up, and it was around what sort of questions should be added to forms around psychosocial health, and what are some options if the employee lies or refuses to complete that part of the form.
I think there are some general questions that you can ask around mental health for some industries, but other industries are going to have to ask very specific questions. And those questions are actually going to be, and as I said, we're going to circulate some example questions that will range from some really general ones right through to some very specific ones, but it will depend on your industry as to what questions you actually ask. You might have, statistical data available that tells you that, for example, there's a lot of depression in your industry, and you have certain ways that you know how to manage that. For example, I think you would then ask that specific question. And you might think, well, how would I know that? It's like, well, as part of your risk assessment, you have to do the research. As an in-house HR or external HR person servicing an organisation, you have to jump onto the internet go to the Safe Work website, do the research, and have that data made available to you so that you can then do it. That's good enough. You don't have to go and get an expert at that point. There's enough data around these days to make most people an expert, particularly with their AI friend next to them.
Yeah. Okay.
But we will circulate those questions with everything that we're circulating.
And
Yep.
what if they what if they lie or refuse to?
Oh yeah, sorry, I forgot about the lie bit.
Yeah. Refuse to complete.
So that can often be a disciplinary issue, but you need to be really careful about how you manage that from a disciplinary perspective. So we have had this in the past where we've had people who, and there are quite a few cases actually, where people have lied on their pre-employment health form and they've said, I've got none. And this is why it's really important what questions you ask and whether or not it's tailored to your industry. So asking those specific questions, you're not just dealing with your health and safety obligations, you're also putting in place an arrangement that actually helps you manage the misconduct of an employee who lies on a form, right? What I would do is make sure that on your form you have an expression of confidentiality, making sure they understand it's going to be confidential, so they can't later claim that, well, I wasn't confident that this was going to be kept confidential and that's why I lied. So you rule out that excuse. If it is a fundamental issue that goes to the issue of an issue with a particular function in your workplace, and you've tried to address that and you've explained to them why you need that information, they're trained on it, it would normally lead to their dismissal very quickly if you found that out. And you need to be careful, but if the person suffered an injury, I mean, I've seen this scenario where, you know, an employee's been subject to some training about a specific thing and then they get injured doing it because they did something really stupid. And then they get sacked because they've done it. Now, in this scenario, it's like, oh, I'm not going to tell you I've got these psychological conditions, even though you've asked me specifically about these conditions. I've started work and now I've suffered an injury, right? Technically, that's misconduct, but it doesn't look great when you're sacking an injured worker because they've been injured in your workplace. You've just got to make sure that if you are moving to that, on one view, from an employment law and contract perspective, you could terminate that person for serious misconduct. But you also need to look at what the downside to that is. Did we have in place the right training? Did we properly educate them about why they should or shouldn't be doing this? Why we were asking for that information? The fact that you asked for someone's psychological, medical information when they first started, and the fact that they later suffered an injury but didn't give it to you at the beginning, is not on its own enough to terminate that person's employment straight away necessarily. What I would do is educate them at the time. You say, we're asking you this information because, let's say you're in an industry where you get a lot of, for example, you know, you work in a hospital and you get a lot of people who come in injured and you've got phobia against blood, right? I mean, they should be, before that person starts, even though you think it's common sense, they should be told, you're going to see a lot of blood here and gore, you know, so are you okay, you know, to work here? Now, I'm being simplistic about that, but it needs to be more detailed than that. They need to be prepared for working in a traumatic working environment. So you need to make sure these people are appropriate to work there. Managing someone, so you've got a person who's a job applicant to work in a hospital, and you say this is a very traumatic environment. And they go, oh, I'm a highly sensitive person. I don't think I can work in that. Like, I think I need you to do things to manage that. Hopefully your system that you've put in place around psychological risks in the workplace, psychological hazards, already has built in certain thresholds. So you don't have to go off and get a medical assessment and get a third person doing, you know, an assessment about whether or not you need to have evidence to exclude this person from your workplace. Because if you don't have that system in place already and you don't hire that person, then they may make a claim. They may say, you didn't hire me because I have a disability. And you'll say, that's right. We didn't hire you because you have a disability, because you cannot perform the inherent requirements of this job. You are unable to work safely in a traumatic environment, and there's nothing we can do to put in controls in place to allow you to work in that environment. And we know that because we've got a system that we've set up. And I'm not talking about a, you know, multi-million-dollar system. I'm talking about the hard work of the HR team or HR and safety teams putting together a system that already has that those thresholds. As I said earlier, though, you do need to be able to work within those thresholds to make sure you're not being too arbitrary about it. If you've got a threshold in place in relation to a person when it comes to things like trauma, for example, you can't just say, oh, yeah, you've got, that's it, you're out. You need to be able to assess whether or not this particular person with their limitations and that they're informed about what your process is, cannot perform the work in that environment. And there are no accommodations or allowances that you can make to permit that person to work in the workplace, so you can defend the organisation and sometimes yourself when you're going through that process. If you're the decision maker, obviously you can be liable too.
Any other questions? Yes.
Hi, Joe. Just on the topic of that, during the onboarding stage, we were providing a health assessment, and your employee was giving us a disclosure around mental health illness or something like ADHD, which we know falls under if there's been a disability. And then at times during the probationary period, there is the chance where they are unsuccessful due to performance-related issues. What sort of liabilities does that then raise in terms of general protection claim or discrimination? If they're actually real performance-related issues that then lead to being unable to perform the inherent requirements of the role, but linking that back to the employee saying, it's because I disclosed this, or I told them this, so this is why they're letting me go. So what sort of liabilities and risk mitigations can we then look at to then not, by those disclosures, cause us potential liabilities?
I'll just quickly summarise the question. It was a good question around, say for example, an employee discloses during recruitment that they have onboarding, that they have, did you say ADHD or an example,
or
as an example, or discloses some illness, and then during the probationary period, the employer develops genuine performance concerns about that employee. So they do a performance process, and the employee then says, oh, well, you're doing this because I've told you about an illness that I have as part of the onboarding. And the question was around what are some of the legal risks and how can we manage that? Is that a fair summary?
You worded it much better.
Do you want to have crack?
Sure. So I think that documentation is really important around that. So it is still possible to conduct that process and have it genuinely linked to the performance concerns, even though the person has disclosed their condition to you. I think what would be important is when you're starting the performance process is just understanding and documenting exactly why the performance concerns are arising, and making an assessment about how linked they are to the person's disability or illness that they've disclosed to you. And then as you're kind of following through the process, keeping that documentary evidence about, well, the issue is that they're not producing enough volume of work, and that's part of their performance, their KPIs or what they need to do in their role, rather than it's because they have this disability. And there are ways around it as well.
Look, I think, and the reason you're asking that question is because quite often someone with a disability who is underperforming will blame it on the disability. And it's about how do you delineate between the two? How do you make sure that you're making a decision about performance and not one that's infected by the disability enough to the point where you've got liability? It is quite an involved process. It's quite a heavy process, and it's a bit like getting a medical assessment, in the sense that you will have to go to the employee and say, okay, so you say that the employee might say something like, oh, I've got ADHD, right? And you say, okay, well, what does that mean? I need to understand from your doctor what that means in the context of what you're doing, because you're telling me you can't do this very well because of your ADHD. I'm not sure that's right, but I'm not a doctor. So we're going to ask your doctor first what it is. So you might have to go through that process of actually isolating each of the issues and crunching right down into the issues. Caroline was saying, documenting it very carefully, so that you can actually separate them. Now, to be honest with you, most employees, when you go through that process, because it is quite involved, of getting medical evidence off them and making sure that they're safe during that process as well. Being as gentle and as nice about it as you can be in the circumstances, which is sometimes hard, but you've just got to do that. A lot of employees just pull out and resign and leave. A lot of employees, but not all. Some dig in and they're in it for the process. And through that process, if you have the stamina and the focus to be able to stick with the process, which can sometimes take weeks and months to get through, you can nearly every single time separate the disability from the performance issues. In fact, when we've been given the opportunity to help a client do that, we've always been able to get through it. The ones that go off the rails is when the employee sort of gets sick of the process. The employee's still in there, hanging in, not doing a lot, but hanging in there. And they say, "Oh, let's just move them on. Well, let's not do that. This is taking too long." It's like, well, it takes time. Unfortunately, it takes time. There is always the option of paying the employee a bucket of money and just moving them on with a deed, right? And sometimes that's more commercial than getting a law firm involved or consultants involved to help you out with that process. But it won't help you with workers' comp claims, because workers' comp claims generally can't be deeded out of unless you're actually paying the person for a work-related injury. So you might deed someone away to get them out of the business, but you're actually just buying them to leave. You're not paying them for any psychological injury they may have suffered. And so the fact that they haven't made a workers' comp claim at that point in time doesn't mean they won't make a workers' comp claim the day after you sign a deed with them.
So how can we prevent that then?
How can we prevent that from occurring?
Yeah.
Don't take the short option that's viewed as being short-term commercial. Sometimes you've just got to stick in there with the process. As I said earlier, if you demonstrate as an employer that you're in this process for the long run, you're going to go through, you're going to tick all the boxes, you're going to get them medically examined. And if you don't like the treating doctor's report because it doesn't properly address your questions from a health and safety perspective, then you'll move on to an independent doctor. And if it's a psychological injury, that might cost the business $5,000 for the psychiatrist consultant.
Yeah.
So
there is no document like the deed of release that we can get the employee to sign on that would prevent them from going to
workers' comp.
To
Look, no, legally speaking, unless the right circumstances are there and you're actually paying them for the workers' comp claim, which generally will not be, comes up once in a while, but very rarely, you cannot rely 100% on a deed. And a deed is the best protection you can possibly get. So there's nothing better than a deed, and a deed is not 100%.
Yeah. How are we going?
Any more questions? We probably have time for one more question, or a short toilet break, or a breakfast break, maybe a coffee. There we go.
Andreas.
So just to clarify, we can ask for a medical certificate during employment or during the employment process for existing staff members. If they say I have ADHD, I have depression, we can ask for clinical evidence to then cater to the correct response moving forward.
Yeah, so if someone says they've got ADHD and you don't have any medical evidence of that, you can ask for proof of that, because you now have you could have asked for it before, but there was a bit more of an argument to be had about whether or not you're entitled to it. But now businesses in New South Wales particularly, but really around the country, have very specific psychosocial risk hazard management. It dictates that if someone's telling you that a medical condition, then you can ask for it. Now, you don't have to ask for it. If you accept that that's the case and you can work with that, that's fine. But there are scenarios, as we know, that you have to ask for a medical certificate because the employee's been absent a lot or whatever. So you need to know what's going on. Andreas.
Am I running the risk? If I don't ask for a certificate because I have to tailor it and really have to go beyond what we had to do in the past, that I haven't done my duty. If I don't ask for it, and if I do get that, to what extent do I have to understand it as an employer without getting the clinical support on my end? Like Spectrum might be a good example. The Spectrum is obviously huge. How do you cater for that?
Yeah, look, it's
Question first.
Sorry.
Oh yeah, the question was, how do we meet our effectively it was how do we meet our duties, like by uh, where we're put on notice about that. Do we have a duty to require to ask for the medical certificate, and where does it start and end? I think when you're talking about an obligation to ask for the medical certificate, I don't think there's an obligation to ask. I mean, if you accept that they've got the condition and you manage it well around that, the real issue is what you do with that information from a risk management perspective. What do you do with it? Have you done anything with it? If someone's told you that they've got a condition, getting proof of whether or not you accept that is not really the big issue at that point. It can be one of the issues behaviorally, but if you accept that they've got that, they're not telling you they've got ADHD as an excuse. If they're just telling you, look, I've got this on the way in the front door as they start their job with you, I've got ADHD, you need to think, okay, ADHD, does that create a problem for us from a health and safety perspective and for them? Do we have anything in this workplace that's a problem for them? And if you don't understand it, to be honest, you do need to do a bit of research yourself. You do. You're not expected to go and get an expert in that environment. But there are times when you will need to go and get an expert and maybe get them to help you do the assessment. I mean, as I've mentioned a couple of times today, even Safe Work New South Wales are getting expert inspectors that are focused on psychosocial health hazards.
I just have one last question, if that's okay.
No, but you can go on.
I'll go on anyways. You did mention that sometimes when you go to court, a verbal evidence is not necessarily adequate enough. So what if there was only verbal, and you said avoid it as much as you can, but what if there is only verbal but there is witnesses? Is that strong enough? Is that stronger?
Yeah, look, I mean, in the hierarchy, the evidence, sorry.
The question was just around verbal evidence in the context of managing WHS risks, and what if you get to a prosecution and there's only verbal evidence but it's backed up by witnesses? Will that be sufficient?
Yeah, look, absolutely. We'll take whatever evidence we can get. We'll look for other evidence as well that's may not have been documented or verbal evidence, be other things. But in the world of being prepared and being proactive, that's why we emphasise the need for written evidence, and that's why we have that mantra at the beginning. Let's take the view that if you didn't write it down, you're not going to be able to use it later on. Now, we say that in the context of, particularly here with psychosocial risks, I mean, it really applies to everything, but we say it here because when you have one person's word over another, that's when verbal evidence becomes a real problem. You don't normally have, a lot of people, I've even seen investigation reports where investigators have said, look, all I've got is one person's version against the other, and I've got no other evidence that points me in any other direction. There's no other evidence that would have me favour that person, one over the other. So I have to split the baby. I have to give them 50-50 and say, I can't make a finding on this allegation. That is very rare, that you actually don't have any evidence that can point you one way or the other. When you're looking at balance of probabilities, and when we're talking about prosecutions, we're actually talking about a higher standard. And when you're talking about criminal, you're talking about beyond all reasonable doubt, not just balance probabilities. But we want to work on the basis of balance probabilities because the other risks here are a lot of civil risks in the workplace context. And we really want to make sure that the business is in the best position to resist any legal attack from anyone, and also to make sure that it's protecting its commercial interests at the same time and its people.
Yeah.
We're moving on.
Yeah. If anyone needs a break, don't hesitate to go get some food, order some coffee, etc. But we are running on schedule, sort of. So as expected. So just as FYI, if you do need to get up, do not hesitate. Do not worry about that. But we're moving on to our next section, artificial intelligence in the workplace. So this is a great one because it's sort of new. It's been around only for a couple of years now, but it's getting worse and worse, I think, for workplaces, the Fair Work Commission and everyone else at the moment. And this is why we want to deep dive into this, because it's a big one. You're going to see a lot more of it, and it's dangerous in all aspects: privacy, how people use it, how it's replacing jobs, etc. So this is a great session to go through. Next one. So I'll just kick off, if that's cool. So what is AI? I'm not going to bore you. Everyone has used something like ChatGPT, etc. But there is a lot of stuff out there. And this is only, I think, literally the top 50. There's probably another 150 out there. They all do different things in different ways, with most of them funny names, right? Yeah, there's one Monica. There's a Monica in there. There's a happy face. There's janitor. There's Veed. So they go between anywhere between helping you with content, helping you with video, hosting your vibe coded application you've created, analyzing data, doing workplace stuff like Claude HR, for example. There's a lot out there at the moment. So this is where you've been obviously the people have heard of ChatGPT, maybe Claude, Copilot. What's the other one people use at work? I'm not sure what's called. Gemini, etc. But there is a lot of things out there that your team, staff, or your clients are probably using and they don't even know about it. So this is why part of this is why this is so important. So I'll pass over to the experts.
You can start.
So there's a lot of ways that AI can assist in the workplace context. And as Phil said, the purpose of today is not to do a deep dive into how it works and what's happening in the background. But essentially, AI can assist with some really narrow task-specific types of things, so like calendar and scheduling assistance here. And it can also go right up to the end of machine learning tools that can actually help analyze patterns in data and help to make decisions. And that's where we get this decision support and recommendation grey tile there as well. Do you have any examples you want to talk about? Or
Yeah, look, I think we're going to talk a bit more in detail about, you know, why this is important and why understanding what it does or what it can do for your business is really important in the context of managing the risk in your business. I don't think it's a smart thing for businesses to completely rule out, most businesses to completely rule out AI. I think most people are using it now. We're using it, but we don't use it to, you know, do our final work, do it for research and things like that. But we've got some examples where people have gone off the rails. And if you don't tell your employees from a disciplinary perspective, this is what we use it for specifically, here's our policy, you've got to comply with our policy, then you can find yourself exposed as a business and in a position where you've got an employee who's done the wrong thing by the business, for example, by pouring a bunch of client data into an open source ChatGPT.
Yeah.
And we heard about that happening in the States with, you know, I think Hegseth poured some data in, or one of his people poured some data in, really confidential, top secret data into an open source AI that wasn't ring fenced to the business, wasn't confidential, and was made public.
Yeah, we have got some examples to come to of that. We also just wanted to quickly talk about potential applications of AI in HR, and I'm sure many of you are using AI for some of these things. And there was also in 2024 a report published by ARI, the Australian HR Institute, and it found that in the HR context, AI was mostly used to help with prompting employees to complete training and employee self-service functions and some drafting work like job descriptions and ads and that kind of thing. What we didn't see too much of in that survey was the use of AI in recruitment. So around things like screening CVs, shortlisting, and even doing some preliminary interview sort of steps. So we just wanted to touch on that.
And this heightens that risk profile right across from recruitment right through, because AI is built, even though it's smarter than some humans, it's built by humans, it's flawed, it's not going to do the right thing, and it's not always going to do the legal thing unless you very specifically program it to. And being a good prompt engineer is going to be a very good job in the future, I think, because I think it's, you know, part of the reason that dictates what comes out of an AI response, and what shouldn't come out of an AI response. So a good prompt engineer can get you a very good result. One who's only done half the job can get you one that can be quite flawed.
Yeah. So what are some considerations that employers need to keep in mind when thinking about using AI in the workplace? We've listed a few on these 6 tiles here, and we're not going to go through all of them, but the ones we wanted to highlight is first the middle one in the top row there around shadow AI use and compliance risk. So what that means is that employees are frequently using AI at work, regardless of whether or not it's permitted. We have a stat coming up in a few slides' time. I think it's 27% of employees are doing this. And the risk of that is that it's happening without organizational oversight. And it exposes the business to a lot of risks. And we're going to come to the risks too, but it's things around privacy, confidentiality, what's the quality of the outputs, which all sort of lead to reputational risk and potentially financial harm as well. The other thing we'll just mention here around the considerations is that there are a few, the AI advantage gap and the low return on investment if rollouts are poorly managed, that link to comms around deciding to implement AI in the business. The AI advantage gap is where the uptake of AI is kind of embraced by tech confident employees, but there's another group who just don't want to embrace it, and that can mean that the rollout in a business context is not as successful as it could be. And then again, that's sort of linked to the low return on investment piece.
Also
there.
a psychosocial risk.
And so the importance of messaging there is really important, and training around how you can get the most out of the AI that you're using.
It also, just on that issue we've got here about skills gap and role design, that is a psychosocial risk process as well. And using AI to help you with that is perfectly fine. But using AI to do it completely, full stop, AI gives me a return, cut and paste into the report, that's not okay. Because if at the end of the day you end up in a court or a tribunal or this inspector and they decide to put your report through an AI detector and it says there's 90% of this is, AI, or this paragraph's 100% AI, you will find that you don't get the credit for having done the assessment because they realize that AI did it, and it may not be correct. If it's correct and it's a paragraph that's been spat out by AI, do yourself a favor and reword it. Get rid of the long dashes, get rid of the bolding and the other funny formatting it does.
Formatting, yeah. Oh.
Change the font,
Yeah.
Put some effort into it.
Yeah. Yes, that's a big one. It does have a few Zs. So what are some of the risks that can happen here? The first one is around privacy. And the risk here is that what information is being uploaded into AI? Is there a risk that client or confidential or personal information might be uploaded? Where is that going to be stored? And what's it going to be used for? Has the person who owns that information consented to it? We have got a screenshot on the slide there of a situation where 3,000 flood victims' details were uploaded into ChatGPT. That was in October last year. And it raised concerns about whether that private information could then be accessed by others because they were in ChatGPT. And the answer to that is yes, there is a risk that that could happen and it could be used for training. But there were ways to kind of manage that. In Australia, the Information Commissioner, who's the regulator under the Privacy Act, has published some guidance around what organisations can do to make sure that their AI use is interacting with the Australian privacy principles. So that's one thing that you can do to help to manage this risk. The other thing is to update privacy policies if you are thinking of getting information and using AI with that. And also making sure that AI policies are consistent with the privacy policies. That is, outline what you expect your employees to do with information. If it's the case that no client information or no personal information is ever to be uploaded into AI used at work, or not, like if you've got a workplace AI or people using it personally, make that clear in your AI policy and make sure it's consistent with your privacy policy as well.
what's really important about this is, from an employment perspective, is that you need to make sure that you've very clearly communicated this risk to the employees who are handling this data, so that they understand